This is the first meeting of the Michigan Jail Reform Advisory Council. I know most of you, I think. Those of you I don't know, I'm Bridget McCormick. I'm the Chief Justice of the Michigan Supreme Court, and I was appointed by the governor to serve as the chair of this new council. And I'm excited to work with all of you as we continue the important work with jails in Michigan and the criminal justice system more generally. I will be spending a little time today talking about reviewing the directives in the executive order, covering some important housekeeping matters. Then I want to make sure you all can introduce yourselves, and so we can all learn about the groups that you have been appointed to represent. In the second part of the meeting, Ryan Gamby with SCAO is going to give a presentation on sort of how we got here, the work of the Jails Task Force, and an update on the legislation that was passed last session. And then we'll conclude the meeting by starting to discuss implementation, what that means, and hearing from stakeholders on how the efforts are currently proceeding. I see some familiar faces here, as I said, and both from the task force and from other parts of life. As many or most of you know, we started the task force work back in 2019 when the task force was created to recommend policies that expand jail alternatives, safely reduce jail admissions, support crime victims, and improve the efficiency and effectiveness of our criminal justice system. The task force worked very hard that year and analyzed extensive data sets from law enforcement, courts, county jails. We issued a final report with 18 recommendations in January of 2020, many of which were codified by the end of the year. Many practitioners have described these reforms as being some of the most significant changes they've encountered in their careers. And I happen to believe that the task force was successful for a lot of reasons, but primarily because we worked very hard to develop bipartisan interbranch state-county partnerships. And we truly listened and listened to and respected the unique perspectives that each of us brought to the table in that process. And we based our decisions and recommendations on data. It was one of the most satisfying experiences I've had in my professional career, and was grateful to be part of it. This council, the Jail Reform Advisory Council, is kind of a follow-on project, but equally important. We are, I should say, charged with ensuring the successful implementation of the reforms and monitoring their progress. But more specifically, the executive order that establishes us directs us to do the following few things. Number one, provide information to criminal justice system professionals by drafting and distributing guides explaining jail reform legislation and their corresponding effective dates. Number two, collaborate with and support local and state agencies with implementation strategies. Number three, identify training needs for government agencies, system stakeholders, and professional associations to comply with the law and provide support as needed, including subject matter expertise, presentations, and educational materials. Number four, coordinate with government agencies and departments to develop and implement necessary changes in forms, technology, and website information. Number five, recommend reasonable timelines for government agencies and key justice system practitioner groups to report on steps taken to implement the statutory and budgetary changes, provide feedback on implementation plans to support compliance, and enhance the likelihood of full and timely implementation. Number six, identify data that can be reasonably collected or sampled to measure the outcomes of the legislation, and partner with key justice system practice practitioner groups to gather that data. And we are to report annually on or before the 15th of January to the governor, the legislature, the Supreme Court, on implementing the jail reform legislation and these measurable outcomes. We're going to meet until March 31st, 2023, when we will apparently dissolve, and then we'll be done. So those are the directives, and it's a lot, and we are grateful to have all of you to help us carry those out. Before we start discussing substantive matters today, I want to go over a couple of housekeeping items. You received an email from Deb Marks on June 18th that contained the Zoom link for this meeting, and you're here, so I know you got the email, as well as several documents. Those include the agenda for today, the names and contact information of everyone on the council, and a copy of the executive order, the final report of the Jails Task Force, a legislative analysis that explains the reform legislation in some detail, and a practitioner's guide that summarizes the reforms at a slightly higher level. I assume you already have, but if you haven't, I encourage you to review those documents and familiarize yourself with the laws we are tasked with implementing and the work that went into their development. The council will be staffed by Ryan Gamby from the State Court Administrative Office with support from Deb Marks. Many of you might remember Ryan when he staffed the Jails Task Force with the Pew Charitable Trusts. So he's been around for a long time, and we're grateful to have him continuing. Ryan and Deb's contact information are both contained in your council roster, and you should feel free to reach out to them anytime with any questions, requests, ideas, comments. The executive order places the council within DTMB and requires us to comply with FOIA. The public records we produce are therefore subject to disclosure and inspection. So to comply with FOIA, DTMB has requested that all members, including me, use a state of Michigan issued email address for all matters related to our work here on the council. And I realize this can be an inconvenience. I think I'm collecting these email addresses now for the different things I have to do. But it's pretty important to promote transparency and allow DTMB to quickly process any FOIA requests that might come in. DTMB has also determined that we are not subject to the Open Meetings Act because we only operate in an advisory capacity and we don't have any rule or policy making authority. But because it still feels pretty important that we are as transparent with our work as possible, we are live streaming this meeting, and we will continue to do that. We want the public to be able to see what we are doing. We think that builds public confidence, and so we are going to make sure we are always posting the meeting schedule on the Supreme Court website and the link to the live stream. And then those will also be available to be watched on the Supreme Court's YouTube channel. If you're not familiar with the Supreme Court's YouTube channel, it's awesome. You should get to know it. Future meetings. Scheduling meetings for a group this large is difficult, and I'm hoping we can meet about every 4 to 6 weeks. And I've emailed a tentative meeting schedule a couple of weeks ago. Please plan on these meeting dates and times for now, but email Ryan if they don't work for you, or if you're requesting some accommodation, and we will figure out what we can do. I'm not going to repeat those meeting dates right now because you have them. But again, if you have questions, Ryan's ready to field them. Okay, with that, I think we should take a moment and go around our screens and meet one another. I guess I always find this kind of complicated to figure out if we should like popcorn it or I should just call who I see. But I think what I'll do is call out council members' names and we can go from there. And I think we are missing some people, but that's okay because we'll know who's here if I go through the list. So is Robin Little here from the AG's office? Hi, Robin. Will you please introduce yourself to the group?
Sure. Hi, everybody. My name is Robin Liddell, and I am the first assistant of the trial section with the Criminal Trials and Appeals Division with the Department of Attorney General's Office. Nice to meet all of you and look forward to working with you.
Thanks, Robin. I don't think I see Director Washington. Are you here, Director Washington? Not today. Captain Hintz from MSP.
Good afternoon, everyone. I'm Dale Hintz. I'm captain of the 6th District, which is the Grand Rapids area in the 14 counties of West Michigan. And I'm here on behalf of Colonel Joe Gasper.
Thank you. Melissa Smiley.
Good afternoon, everyone. My name is Melissa Smiley. I'm the Chief of Staff for the Michigan Department of State, and I'm here on behalf of Secretary Benson. Again, very excited, like everyone else, to join.
Thank you. Deborah Kane.
Hi, I'm Debbie Kane. I'm the Director of the Division of Victim Services in DHHS, and I'm here on behalf of and at the appointment of Director Hertel and DHHS.
Thank you. I don't think I see Sheriff Clayton. Is anybody here for Sheriff Clayton? Nope. Barb Henke.
Good afternoon. It's nice to see everyone. My name is Barb Henke. I'm representing community corrections agencies and pretrial agencies across the state, and I'm the manager for Oakland County Community Corrections.
Thanks, Barb. I don't think I see DJ Hilson, Prosecutor Hilson. Oh, yes,
I'm here.
DJ,
Yeah.
DJ, there you are. Sorry.
No problem. Hello, everybody. It's great to see some familiar faces, although it's virtually, but hopefully we'll get over that soon. DJ Hilson, Muskegon County Prosecutor, representing prosecutors from the state.
Welcome, DJ. Takura Nayam Fakutsa.
Because I was called on by the Chief Justice, I've risen to my feet. Takura Nyamfukudza. I'm a criminal defense practitioner, practice all over the state of Michigan at the trial and appellate level. I represent the Michigan Indigent Defense Commission. Thank you.
Thank you, Takura. Bill Peterson.
Hi, everybody. My name is Bill Peterson. I'm County Commissioner from Alpena County. I was tasked with this job through MAC, and happy to be here and continue with the task force.
Good to see you, Bill.
Thank you.
Dr. Posios.
Hi, Vasilis Posios, Chief Medical Officer, Oakland Community Health Network, board certified in psychiatry and forensic psychiatry, and worked for 10 years in the Michigan Department of Corrections, treating individuals incarcerated there before moving over to the world of community mental health. So very passionate about criminal justice issues and glad to be here. Great,
we're glad to have you. Is Chief Riley here?
Yeah, good afternoon. I'm William Riley, the police chief from Inkster, and of course I'm on the law enforcement side of it, and I also a little bit of the mental health side of it, as well as I'm the board chair for Detroit Wayne Mental Health, or DWIN. But glad to be here.
We're glad to have you. Is Judge Edwards here? I don't see Judge Edwards. Nope. Judge Fuca.
I knew you were going to call on me just at the same time that my neighbor's seawall is being put in next door.
That's the way it goes. That's the way it's supposed to go.
Yeah, I'm really happy that I chose to do this from home today. So I'll have my computer on mute probably lion's share of the time. But my name is Judge Carrie Lynn Fuca. I am representative of the Michigan District Court judges. I preside in Macomb County over a district, Mount Clemens, Clinton Township, and Harrison Township. And I currently preside over drug treatment court as well as a veterans treatment court. So hopefully I'll have some good stuff for everybody. And I'm excited to work with you guys.
We know you will. Thank you, Judge Fuca. I don't see Senator Runstead. Am I missing anything? Nope. Senator Santana.
Hi, good afternoon, everyone. Senator Santana here. It's a pleasure to be with all of you once again. Some of you are new, but definitely we look forward to continue this great work that we've started. And definitely we have a tall task ahead of us, but I'm up to it. And I know that all of the members on this task force are up to it. And also the members who are not here from the House, they're in session currently. So thank you all so much, and look forward to working with all of you.
Thank you, Senator. So that explains why I don't see Rep. Mueller or Rep. Yancey, but we'll see them next time. Did I miss anybody? All right. Well, again, welcome. We know you have full-time jobs already, and this is just one of those extra things that when you fit it in means you're doing something else after hours. I know that, and I'm really grateful that you're willing to do it anyway. As I said earlier, our work is building on the work of the Jails Task Force, the work we did in 2019 and then 2020. And so to get us started, we want to make sure we're all on the same page about the legislation that was enacted and the implementation efforts that are underway already. And so thank goodness we have Ryan Gamby to take over for me. So Ryan.
Thanks, Chief. A quick share my screen here, assuming that goes to plan. All right. Can everyone see my screen there, the PowerPoint? Okay, excellent. So again, good afternoon, everyone. Definitely appreciate you taking out time out of your day to join us. My name is Ryan Gandy, as the chief indicated. I'm a court analyst with Scale. A little bit more specifically today, I was asked to staff the Jail Reform Advisory Council. As the chief mentioned, I had the honor and privilege of also working on the original Jails Task Force alongside Pew, so I do have some familiarity with this topic. I think it's important. I understand, going over the history of certain things isn't necessarily always the most exciting topic in the world, but I want to take just a brief moment of our time here today to review the original work of the Jails Task Force. I'm going to spend a little bit of time explaining how it came about, briefly cover some of the preliminary high-level findings that the task force made. But then the majority of my presentation here today is going to be focusing specifically on the legislation that was passed this past legislative cycle. It's obviously important that we have kind of a firm understanding of what the legislation actually is and how it operates, since we're tasked specifically with ensuring the successful implementation of it. So, contact information, as the chief indicated, is in the roster. I've also included it at the end of the presentation. Please do not hesitate to reach out whatsoever. I'm more than happy to be put to work, and I want to make sure that I can assist you individually and also the council collectively, so that we're successful in our directives and objectives here. So starting off here, this picture was taken at a signing ceremony, if you can believe it, all the way back in April of 2019. That seems like forever ago, especially with everything, the trials and tribulations that we've been through in the last year. But that is when the original Michigan Joint Task Force on Jail and Pretrial Incarceration was formed. The kind of reason why this task force was formed is we knew, but didn't necessarily know why, that county jail populations had really kind of exploded. They had more than tripled over the last 40 years, despite continually falling crime rates. The issue with county jails, similar to a lot of individual courts, is they're managed individually at the county level by the county sheriff. That means that jails can employ their own case management system, and while we might be able to get specific data from one jail in particular, it's really hard to get statewide collective data. So the task force was formed to investigate that with kind of general directives to provide recommendations to safely reduce jail admissions, length of stay, and then costs. And as the chief mentioned, we issued our final report and recommendations in January of 2020. The legislature worked very hard throughout the year, despite everything that was going on, to codify these recommendations at the end of the year. And then they have started to become effective throughout 2021, this year. So starting briefly with a very high level overview of the findings. And in that email that Deb Marks had sent you the documents, we actually included the actual report, the report and recommendation from the Jails Task Force. I would encourage you to look through that. I'm just skimming the surface here with the presentation today, but there's a lot of really good information there. So as I mentioned, the graph on the left here is a representation of our jail populations from 1970 to 2015. It is depicted in two different categories. The light gray color represents our convicted population. So these are the defendants who've actually been found guilty and are serving a term of incarceration in the county jail. And then the dark blue represents the number of our pretrial detainees. So these are defendants who are still waiting for their day in court, that have not been found guilty of a crime, and are being held in custody for either that a bail was not set, it was denied by the court, or bail was set in unaffordable amounts that they're unable to pay or that someone else is unable to post. And in Michigan, it's been about a 50-50 split, and it has been that way for quite a few years here. So our jail populations have been driven primarily or equally between convicted and unconvicted populations. The Jails Task Force found or noted that jail growth has been faster in rural communities in recent years than in urban and suburban areas, and it's expensive. It costs taxpayers about $478 million on county jails and corrections costs in 2017 alone. When we look at who's actually coming into the jails, I've included the top 5 charges here. First is OWI. The second most common charge was assault and battery. Third is DWLS, which stands for driving with a suspended license. Fourth is theft. These are your retail frauds, your larcenies, that sort of thing. And then lastly here was probation and parole violations. So folks who are on probation or parole but violated it and were lodged as a result of that. This next graph here is fairly interesting. It takes a look at jail length of stay by admissions. So as we can see here, jails are a fairly high traffic institution. There's a lot of people who are being booked into jail and then released fairly quickly. There's a much higher level of turnaround than say individuals booked into state prison. On the very left of this chart here, you see that 66% of all jail admissions, about 2/3, are released within 1 week. And because they're released so quickly, they only occupy about 5% of all available jail beds. On the other side, on the far right of that screen, we see that only about 17% of all jail admissions stay for more than a month, so a small portion of total admissions, but they're collectively responsible for about 82% of all jail bed use. And that makes sense, right? I mean, the folks who are being booked in on more serious charges, there's fewer of them, but they're staying for longer periods of time. But importantly, it led the task force to come to the realization that any sort of policies that just solely address the number of admissions isn't going to really reduce the number of jail bed days that are being used. And on the other side, policies that only focus on reducing jail beds aren't necessarily going to reduce the total number of individuals who are being booked. So when we talk about the actual laws that were implemented, they really address both length of stay and who actually goes to jail in the first place. Demographics, there is a lot more to be said on this topic, but this is just one example. Black men who comprise about 6% of the total county populations that we studied, yet they represented 29% of all jail admissions booked into jail. So a very clear disparity there between what they comprise in the general population as opposed to who's actually being booked into jail. Mental health, another huge topic here, but generally speaking, people admitted to county jails have much higher rates of mental illness than what we find in the general population, and this is especially true in rural counties. So on average, the jails task force reviewed literature that said about 4% of the general population would screen positive for having a serious mental illness. It goes up to 23%, so almost a quarter of everyone who's being booked into jail, if screened, may screen positive for serious mental illness. So there's a lot of discussion going on about mental illness, criminality of it, and how we address that in the criminal justice system. Case types, a lot of people don't know, but traffic violations comprise a significant amount of the district court docket. Approximately half of all cases in district court are traffic cases. And nearly 9 in 10 cases filed in district court, at least in 2018, were misdemeanors. I think most of us are aware, but just for clarity, criminal offenses are divided into 2 broad categories: misdemeanors and felonies. Misdemeanors are those offenses that are generally punishable by 1 year or less in county jail, and felonies are those that are more serious, punishable by 1 year or more, generally in the state prison system. License suspensions is the second to last thing I'll note here. As we'll talk about here, there's a lot of different ways in Michigan, or at least there was, that a driver's license could be suspended. In the stat that we have cited here, in 2018, the state of Michigan had suspended nearly 358,000 driver's licenses for failing to appear in court or failing to pay certain fines and costs. And one of the consensus that the jails task force came to is that suspending a driver's license does have a place and purpose. It's important that we take unsafe drivers or dangerous drivers off the road, but there really should be some sort of nexus or correlation to unsafe driving when we use that as the basis for suspending someone's driver's license. And not showing up in court or not paying a fine doesn't necessarily meet that test. It doesn't have that threshold. It doesn't have that nexus. So that was the basis for some of the significant recommendations in the legislation that we'll review here in a moment. And then lastly, community supervision. Michigan was determined to have the 6th highest rate in the country of individuals under community supervision programs. That includes district court probation, community corrections, pretrial supervision, parole. A very high number of individuals, even if they're not incarcerated either in jail or prison, are under supervision in Michigan. So those are the high level findings. As I mentioned, the task force issued their final report and recommendations in January. The reforms that became effective, some of which are already effective. The first batch became effective in March 24 of this year. Another big chunk became effective on April 1st. And then the last chunk is going to be effective October 1st here, which we'll describe in detail. So rather than going through the individual recommendations, I think it might be a better use of our time to just jump directly into the legislation primarily because the legislation closely mirrors what the recommendations were already. So the recommendations and the laws here really span the entirety of the criminal justice system, and I'm going to address them kind of in sequential order. So I'm going to start talking with arrests and probable cause determinations. We're going to move then on to warrants and summons. We'll progress to judgment and sentencing, and then finally we'll wrap up with probation, parole, and discharge from probation. So that's kind of the order that we're going to follow here. There's no need to like frantically write down everything that's on the PowerPoint. We'll make this available to you so you have that. Additionally, I've included in the lower right-hand corner the Public Act that references each of these slides, as well as the effective date. So you have both that reference and you'll know which ones we're talking about are actually effective and which ones aren't yet. Additionally, there is a document that we distributed. It's called a legislative analysis that was completed by our office that goes into very specific detail on all of these reforms. So again, this is just a high-level overview. That document is definitely the authority when it comes to sorting through all the nuances of the law. But starting with arrests. Generally speaking, a law enforcement officer on the street can initiate a criminal case against a defendant in one of two ways. They can, if they have probable cause and for certain offenses committed in their presence, they can take them physically into custody, to make a custodial arrest and book them into jail. The other way that they can initiate a case against a defendant is issuing what's known as an appearance ticket. And it's a form almost identical to the ticket you would get if you were speeding or something like that. But instead of taking the person to jail, the officer can indicate a specific day for the person to appear in court. The benefits of that are huge. Obviously, the person isn't brought to jail. If they're on their way to work, they can continue on to work, so on and so forth. The Michigan law currently allowed, before these reforms took effect, officers could issue appearance tickets for offenses that had a maximum penalty of 93 days in jail. The legislation here expanded that to include 1-year misdemeanors. So there's a greater number of offenses now that are eligible for an officer to issue an appearance ticket instead of making a custodial arrest. There are certain ineligible offenses. And as you'll see here, this is kind of a reoccurring theme. There are carve-outs and exceptions to just about every one of these things to preserve public safety and whatnot. But ineligible offenses, officers cannot issue these tickets for domestic violence offenses, for PPO violations, certain offenses that are subject to a mandatory period of confinement, serious misdemeanors, and assault of crime. And you're going to hear the term over and over again: serious misdemeanor, assault of crime, violent felony. These are all statutorily defined terms. And in that legislative analysis, I believe it is Appendix A, or it might be Appendix B. I've actually gone through and identified each and every crime, the charge code that qualifies as being a serious misdemeanor or assault of offense. So just consult that. You don't need to go in and try and look up individual offenses to determine what qualifies. So if it's a 1-year misdemeanor, it is not an ineligible offense. There is the assumption that an officer will issue an appearance ticket as opposed to making a custodial arrest, unless one of these 6 exceptions apply. If the defendant is not following the officer's reasonable instructions, if they fail to identify themselves, if there's community safety concerns. And then number 6 is the catch-all. It's any other reason the officer may deem reasonable to arrest the person, as long as they can articulate why they're doing so. So again, that's kind of the safety relief valve, but this is how this functions, again, trying to reduce the number of folks who are actually booked into jail. Warrants and summons. So we just talked about how a police officer can initiate a case, but in some circumstances, a defendant may not be present for an officer to make an arrest. In other circumstances, an officer may prefer to submit his or her police report to the prosecuting attorney and have them review and determine which charges should be brought. So when a prosecutor is reviewing these cases, they will submit a complaint to the court. The court will review it, and upon finding a probable cause, will do one of two things. The court will either issue an arrest warrant that will be entered in the system, and the defendant will be taken into custody the next time they encounter law enforcement, or the court will issue a summons, which is kind of like the court's version of an appearance ticket. They direct the defendant to appear in court on a certain date, and they mail it to the defendant's house. And if they don't show up, then the court can issue a warrant. I've been working in the criminal justice system for several years, and I feel safe saying, at least anecdotally in my experience, before this law went into effect, the way it normally worked is that courts would issue a warrant. Some courts would issue summons, but I think the general practice is that upon being presented with a proper complaint, the court would issue a warrant. And some folks don't necessarily need to be booked into jail. Some are perfectly capable of showing up to the court if they're directed to do so without an undue risk to society. So this law kind of flipped that on its head. The presumption now is that the court, a judge or magistrate, is to issue a summons rather than an arrest warrant unless one of these exceptions apply. Number one, it's an assaultive crime. Number two, the court determines that there's reason to believe from the complaint that the person will not appear upon the issuance of a summons. If there's some public safety concern that necessitates the immediate issuance of a warrant, or if the prosecutor requests one. So those are the exceptions under which a court can issue an arrest warrant as opposed to a summons. Other than that, the default is court should be issuing a summons and letting defendants have an opportunity to voluntarily appear. So despite all of that, there's obviously and unfortunately a large number of defendants right now that have active either arrest or bench warrants in the state of Michigan. And until this law took effect, there really wasn't any sort of incentive for defendants to actually show up in court, resolve their warrant, and keep moving forward with the case. So that's what this particular law does. It tries to incentivize individuals to turn themselves in on warrants so that the case can continue and proceed and we can have a resolution of the case. There are some qualifiers, as you can see in the middle of the screen here. Number one, the warrant can't be for an assaultive crime or domestic violence. The warrant has to have been issued within the last year. So we're not talking about folks who've been on the run for 5-6 years or anything like that. It has to have some degree of recency. And then lastly, the defendant must not have previously benefited from this procedure on any other pending criminal charges. You get one bite at the apple, so to speak. This isn't something that you can continue to run and exercise and enjoy the benefit of. But if the defendant meets all of those qualifications and he or she walks in the front door of the courthouse, says, hey, I've got a warrant, I want to resolve it. If the judge or magistrate is available to arraign the defendant, they can do so as long as they can do it within 2 hours. If a judge or magistrate is not available within 2 hours, the court under the law is directed to cancel that warrant and schedule the case for a future proceeding. So allow the defendant to leave and come back for a future date at an arraignment. Additionally, the defendant enjoys the presumption that they are not a flight risk when they're being arraigned on this, which makes sense, right? I mean, by definition, they're really not a flight risk by virtue of the fact that they walked in, they're presenting themselves to the court and they want to take care of this. So that is an additional benefit that defendants have when it comes to arraignment under these specific circumstances. I'm not going to get too much into detail here in terms of the flow chart here, but I forgot to mention that a significant reason for arrest in Michigan is arrest on failure to appear warrants. Defendants do fail to appear in court and for a variety of different reasons. Obviously, there are those defendants who fail to appear because they are intentionally trying to avoid prosecution, they're trying to flee, and so on and so forth. Those folks need to be brought to justice, right? But there's also those defendants who don't show up in court for arguably less nefarious reasons. These are the defendants who, whether it's a good reason or not, I'm not saying these are good reasons, but they may have forgotten their court date. They may have had transportation issues. They maybe weren't able to get someone there for child custody or child care. Maybe they had to choose going to work because they knew if they didn't show up, they were going to lose their job. These are all valid considerations. Again, not an excuse for missing court. But the way that this law operates is if it is the defendant's first failure to appear on the case, they get a bit of a grace period. They get a 48-hour grace period where the court is going to hold the warrant essentially in abeyance to give them a chance to show up in court before the warrant issues. Now, again, there's exceptions to these, and you see those on the right side of your screen. If the court has reason to believe that the defendant is committed a crime, if there's going to be public safety, considerations, the court can issue a warrant immediately. But absent a determination or some reason to believe that any of those factors are applicable, the court should wait 48 hours or must wait 48 hours before issuing a bench warrant as a grace period. Okay, moving on to judgment and sentencing. So this particular legislation was actually introduced by Senator Santana, and it is pretty extensive in terms of the reforms and benefits for Michigan defendants here. The way that this operates is it establishes a rebuttable presumption that individuals that are convicted of a non-serious misdemeanor, and again, that's a statutorily defined term, they're presumed to be sentenced with either a fine, community service, or other non-jail, non-probation sentence. So again, Michigan's sixth highest rate of individuals with people under community supervision, growing jail populations. If it's a non-serious misdemeanor, we start with a presumption that you're not going to get jail or probation. Now, the courts can depart from this. It's a rebuttable presumption, right? So they can depart from this upon a finding of reasonable grounds that's stated on the record. Reasonable grounds is not defined, unfortunately, in statute, but at least in my opinion, on the spectrum of burdens, I think reasonable grounds falls probably somewhere on the lower end of that. I don't think it's a particularly high burden for the court to overcome if there is a reason for why someone should be sentenced to jail or why they should be placed on probation. But again, the courts have to show their work. They have to articulate that on the record and establish a record, an appealable record. If the defendant does not comply with a sentence, they are subject to possible contempt charges for disobeying a court's order. HIDA, the Homes Youthful Trainee Act. I think most of us are familiar with this, but I'll just briefly review this. HIDA operates, or was initially passed. This is an existing law. The amendment just changes some things with it. Operates on the assumption that, you know, as young adults, as teenagers, and folks in their early 20s, we make some poor decisions, you know, and perhaps decisions that shouldn't follow us for the rest of our lives. So the way that HIDA works is if, before this law went into effect, if you committed a certain eligible crime after your 18th birthday, but before your 24th birthday, the court could sentence you or place you on probation for a period of time. When the court did that, the entire case became a non-public case. And if you successfully completed probation, the court would dismiss the case. So it's not something that's on your record. It's not something that is going to follow you around for the rest of your life. Well, brain science, neurological science, you know, has started to indicate that, you know, our brains really aren't done fully developing until like the age of 26 or so. So HIDA here just kind of aligns that with some of the emerging research. It increases the eligibility from age 24 to 26. However, the prosecutor must still consent to HIDA for offenses committed on or after the defendant's 21st birthday. Probation. We'll be spending a little bit of time here talking about probation because there's been a lot of changes here in how this operates, particularly with influencing district court judges and circuit court judges. But under the new law, courts are required to, when they're putting someone on probation, they are to determine and articulate the rehabilitative goals of probation at the time of sentencing. We've modified our scale form so that there's actually a spot for courts to articulate this and write this. But again, the purpose behind probation is rehabilitation. So it makes sense that if someone is being placed on probation, that the court can articulate what they want done, what they hope to accomplish, and what they hope to achieve. It provides clarity and also lets the probationer know what they should be working towards. The courts are to consider input from the victim and must specifically address harms that are caused. Probationers are allowed to report virtually to the probation officers if allowed by their probation officer now. And then the conditions of probation, there's some additional restrictions on what the court can order. Before this law took effect, it was pretty open-ended for courts. Courts, you know, as long as it was somewhat reasonable or somewhat related, the courts could really impose or craft any conditions that they want. Now, they still have a tremendous amount of judicial discretion, but there are some amount of constraints here. Number one, probation conditions must be individually tailored to the probationer, which makes sense. Number two, they should specifically address the assessed risks and needs of the probationer. They're to be designed to reduce recidivism and then be adjusted if the court determines that adjustments are appropriate. And that cuts both ways. You know, if on probation the court determines that there's something else that needs to be addressed, they can impose an additional condition. Likewise, if there's a condition that's no longer applicable because of the probationer's conduct and how well they've done, they can reduce it or eliminate it or restrict it. So it goes both ways there. Length of probation, just generally for felonies, there are some exceptions here, but before this law took effect, as a general matter, felonies were subject to up to 5 years worth of probation. For misdemeanor offenses, it's 2 years, and that hasn't changed. Excuse me. But for felonies, the courts can no longer sentence you to 5 years of probation right off the bat. The most that they can do at the time of sentencing is 3 years, but the court can extend it for 2 times up to 1 year at a time for specific reasons. So if you're coming up at the end of your 3-year term, you still haven't accomplished what we want you to, the court can send it from 3 to 4, and then again, 4 to 5. But each time the court must determine that a specific rehabilitation goal has not yet been achieved, or that a specific articulable and ongoing risk of harm to a victim still exists that can only be mitigated with continued probation. The exception to this, I know we all love exceptions because they're so easy to keep track of, but the exception to this is violent felonies. The court still can sentence to 5 years of probation right off the bat. So that is an exception to that rule. Okay, so we've talked about sentencing eligibility. We've talked about the length of probation. We've talked about the conditions of probation. We're now going to move on to early probation discharge eligibility. Again, the underlying kind of prevailing theory here is that we only want folks on probation if they need to be on probation. And if they've achieved everything that we want them to, let's not supervise them anymore, right? So this tries to standardize an early discharge process for defendants who've been successful before the end of the term of their probationary period. So the way it works right now is after a defendant completes half of their original probation period, they become eligible for early discharge. So if you have a 2-year period of probation, once you hit the 1-year mark, you may be eligible for discharge. The court is required to notify defendants at the time of their sentencing of how this process works. And then again, there are ineligible offenses, which are contained in that statute and also are identified in your legislative manual. So in terms of notice, once the probationer has completed half of their original probation period, and if they've completed all of their rehabilitative goals, all their required programming, the probation department may notify the sentencing court that they may be eligible for discharge. It's a may, it's not a must. So the probation department does not have to provide that notice if they choose not to. If they don't, then it falls to the probationer, and the probationer can step up and provide that notice to the court on their own behalf. There's an additional requirement, though, if the probationer is making the notice. They've got to be halfway through probation, completed all required programming, and they must not have had any probation violations within the preceding 3 months. So there is a difference between who is making that notification. Let's see here. When the court receives that notice, either from the probation department or the probationer, the judge will conduct what I kind of refer to as like a preliminary review of the case. So they're going to review the case and they're going to determine if the probationer's behavior while on probation warrants an early discharge from probation or not. Importantly here, a probationer who has made good faith efforts to make payments must not be considered ineligible for early discharge solely due to an inability to pay. So if you still owe outstanding fines and costs, but you've been sticking to your payment plan or trying to make good faith efforts to pay what you can, you are still eligible for early discharge and the court can't deny you that benefit on that basis alone. Process works slightly different though if there's outstanding restitution that's owed to a victim. If the defendant owes restitution to a victim, the court must also consider the impact that an early discharge would have on the victim and the likelihood of continuing restitution. Now, again, if the court makes a determination that there's been a good faith effort to pay restitution, the court has 2 options. They can either grant the early discharge just like normal and discharge the defendant from probation, or they can retain that defendant on probation, and here's the kicker, with the sole condition of continuing restitution payments. So they're still on probation, but the only condition that they have is continuing that restitution payment. If the court, after conducting that preliminary review, determines that yes, this individual probationer is deserving of an early discharge, the court can go ahead and authorize that early discharge without conducting a hearing, unless for felonies the victim has required or requested certain notice under the Crime Victims' Rights Act, or with misdemeanors if there's certain offenses. And there's, again, the offenses are enumerated in statute and in your legislative analysis. But they're primarily offenses that have a victim involved, so that the victim has an opportunity or at least some degree of input and say into someone being discharged early from probation. If the court, after conducting that initial determination, decides that, no, I'm not sure that this person is really truly deserving of an early discharge, they must schedule a hearing at that point. And the purpose of the hearing is to give the defendant an opportunity to argue their case, to present to the court, their rationale for why they think they should be discharged early. And the court must find at that hearing, if they wish to continue probation, that again, we've seen these before, that a specific rehabilitative goal has not yet been achieved, or that specific articulable and ongoing risk of harm can only be mitigated with continued probation. Okay, so moving on to the last part of probation here is the probation violation process. So unfortunately, these obviously do happen, and the legislature has kind of broken these up into 2 categories of offenses that they coin technical probation violations and then non-technical probation violations. Non-technical probation violations are those violations of probation that are also new violations of criminal law. So every defendant that is placed on probation will have a specific probation condition that says you are not to violate any criminal laws. So if you're on for retail fraud on probation, you go out and commit another retail fraud. Not only have you violated probation, but you've committed a new violation of the law, which you can also be charged for. That's a non-technical violation. Technical violations are those violations that are a violation of your order of probation, but are not in and of themselves a new violation of the law. So if I'm on probation for retail fraud and I have a 7 p.m. curfew and I don't show up home until 8 p.m., I violated probation, but showing up late to my house is not a new violation of the law. So it's a technical probation violation. And this distinction becomes important because for the next slide here, we're going to discuss sentencing and how long someone can be sentenced to jail is dependent on whether it's a technical or non-technical violation. The more expansive definition of non-technical violations are included here. So I've already talked about number 2, violating a new law is a non-technical violation, but so is violating a no contact order. So if I'm on probation for domestic violence and I violate my no contact order with having contact with the victim, that is a non-technical violation of probation. If you're on felony probation in OWI 3rd and you consume alcohol, likewise a non-technical violation. And then lastly, if you abscond, which is defined as being absent or going AWOL for 60 days or more, that is also a non-technical violation. The only caveat to this that I want to point out is that missing or failing a drug test is a technical violation per statute. So although you would argue, you tested positive for cocaine, you therefore use cocaine, which is a new violation of the law, that would ordinarily make sense, but the statute specifically accepts that out. So testing positive or failing a drug test is a technical violation of probation. Moving on to sentencing here, and this is again where that distinction becomes important. There are caps for how long a court can sentence you to jail for a technical violation, depending on what you're on probation for, if it's a misdemeanor or a felony, and how many violations you've previously had. So if it's your first offense technical violation and you're on probation for a misdemeanor, it's 5 days. So going back to my retail fraud case, I show up late for curfew, it's my first violation. That's a misdemeanor offense, that's my first violation. 5 days is the most that I can do in jail. If it's a non-technical violation, the court is not bound by these and they can revoke your probation and sentence you up to the maximum allowable time under the original offense. The exception to this rule is if the defendant is awaiting placement in a treatment facility. If they're trying to be transferred to residential treatment, a bed isn't available, the court can hold them in jail for up to 45 days if they're waiting that transfer. And then importantly too, if multiple technical violations arise out of the same transaction, for the purposes of this law, is to be treated as a single violation. All right, and I'm not going to spend too much time on this, but this reviews how courts are supposed to initiate probation violations, similar to the warrant and summons distinction that we talked about. For technical probation violations, there is the presumption that the court will issue a summons or a show cause as opposed to a warrant, unless one of these exceptions here apply. All right, and almost done here, so bear with me for just a few more slides, but this is our first set of laws that actually are not effective yet. These will become effective on October 1st. These are reclassification from misdemeanors to civil infractions. Basically, all of the offenses you see on the screen right now are currently misdemeanors. So if you go out and do any of these things today or tomorrow, you can get charged with a misdemeanor. They are being changed to a civil infraction, effective October 1st. Driver's license suspensions. Again, as I mentioned before, the task force had kind of an underlying belief and determination that driver's license should only be suspended for reasons related to unsafe driving. So the way that this works, and again, this is going to be effective October 1st, is there are several criminal offenses now that upon conviction will not result in an automatic license suspension. Using a false ID for a minor to purchase alcohol, for example, furnishing alcohol to a minor, MIP second or third offense, all things we don't want to see happen, right? And they're still misdemeanor offenses, but they won't any longer result in a suspended driver's license because there's no relation to unsafe driving. The law here also repealed its MCL 257.319E. This was the statute that required license suspension upon conviction for various controlled substance violations. So Before, the law was changed, possession of marijuana, for example, if you're found guilty of it, your license would be suspended for a period of time. This eliminates that, again, because it's not necessarily related to driving. And then it also requires the Secretary of State to waive reinstatement fees. If your license is suspended today, that is effective October 1st. If it's suspended for a reason that is no longer eligible on October 1st, the Secretary of State is directed to reinstate those licenses if it's for a reason that's no longer eligible. Driver's license suspensions for failing to appear in court. This is pretty technical, and I drafted this more for court administrators and judges. But suffice it to say that license will no longer be suspended for failing to appear in court unless it is for an offense for which suspension is allowed under the Act. So OWI, for example, if you're convicted, you're going to have driver's license ramifications. If you fail to appear in court on an OWI, the court is still going to suspend your license or at least provide notice to the Secretary of State about that. Front of the court suspensions, as most of us know, if defendants don't make adequate payments on their FOC cases, there is a remedy to suspend a driver's license. All the law did here, it's still a possibility, but all the law did here is include a couple additional requirements before the court can make that suspension. They have to conduct an ability to pay determination, and the FOC has to make a determination that no other sanction would be effective in assuring regular payments short of suspending a driver's license. And then the last slide here is the mandatory jail minimums. Basically, all that these did is it eliminated the mandatory minimums that a court had to sentence someone to jail for a variety of different offenses. I believe it's on page 25 of your legislative analysis where I've gone through and identified all of the offenses that had a mandatory minimum that was changed. So I won't go through all those today, but if you're interested, please consult that list. Just briefly, since this has become effective, the State Court Administrative Office has kind of been trying to head up a lot of these implementation efforts. To date, as I mentioned, we created that legislative analysis. Myself and our State Court Administrator, Tom Boyd, have conducted several different trainings for judges, for district judges, circuit judges, district court probation officers. And we've also revised all of our court forms. We've reviewed our court forms to determine how these changes impact them. We've revised them and published them. So again, here's my name and contact information. The top email address is my court's email address. So if you have any non-council related questions, feel free to email me at that one. For FOIA compliance, so if you have questions related to this council, please email me at the second email at the bottom. So with that, Chief, I'll turn it back over to you, but I'm more than happy to answer any questions too, if anyone has.
Yeah, let me open it up, Ryan, for any questions before we move on. Questions for Ryan?
This is Barb. I have a question, Ryan, and I guess it goes more to just mindset. And when you're talking about the non-technical violations, and that I forget exactly how the slide looked, but that drug tests are still technical violations, but a positive test for alcohol is not.
I'm not sure if you saw that.
Yeah, that was the slide I was talking about. It was up there for a second, but
oh, you were able to see that? I wasn't sure if that was. Let me share it again here. All right, do you see that?
Yes.
Yeah. So a positive test for alcohol is a technical violation, unless it is because you're on probation for an OWI third. So if you're an OWI third defendant and you test positive for alcohol, it is a non-technical violation. If you're a second offense defendant or a first offense and you test positive, it is a technical violation.
Okay, that's just a little bit of a change of mindset, especially for treatment courts. And I know Judge Fuka is on here as well. And even though she runs a district court, so this might not be applicable when someone in the treatment court relapses, which we expect them to do. We've generally treated that as a technical violation in many cases.
Sure. Yeah, and I'll say, I mean, the final version of this legislation is obviously not an exact replica or copy of what was contained in the original recommendations. There were some things that changed and naturally do as they go throughout the political process. And I think this may have been one of those. But Just because it is a non-technical violation doesn't mean that you still can't treat it as such in your own treatment court. You know, the court can technically revoke probation and sentence to jail, but it's still up to the court if they want to address it, you know, informally as a technical violation, they're free to do that.
Okay, thank you.
Thanks, Barb. Thanks, Ryan. Other questions for Ryan? All right. I had us scheduled to take a break before the next part of the meeting, but I'm thinking we could push through and just give everybody back a significant amount of time that they may have bargained for. I'm seeing nodding and thumbs up, so I'm going to do that. The next thing I wanted to do today is just hear from council members about how implementation efforts are proceeding so far. To the extent, obviously, you know, your reports might be anecdotal right now, but we'd love to learn what some of you can tell us. As Ryan mentioned in his presentation, most of the reforms became effective in early April, and then the rest won't become effective until October. So I know there'll be a lot more to hear on this topic as we move along. But for now, I wonder if we could hear from our prosecutor and sheriff and judicial representatives to give us a brief summary about how their organizations have implemented. That doesn't mean I don't want to hear from the rest of you. I was trying to hear from the folks who might have the most important information up front. So DJ, can I call on you? Do you have anything you can tell us so far?
Sure, happy to. First and foremost, I have to certainly give a shout out to Ryan and all the hard work he has done to help make this process as smooth as possible. And as practitioners, I mean, we all know there's going to be hiccups along the way. And the other acknowledgement I'd like to make is to Tom Boyd. As much as I hate to make his ego any bigger than it already is, he was really very helpful to us as an association in working through this legislation as it was coming through the pipeline, and was very attentive, listened, certainly made some changes based off our suggestion. And so I really, as a representative of the Prosecuting Attorneys Association, we certainly appreciate all of that, because again, it really helped make this process a little bit more smoother. As it relates to implementation, I mean, for those who weren't part of the task force originally and all that, and all the other things that led up to the legislation, I mean, these were monumental shifts in how we do things and thinking. I mean, I've been in the prosecutor's office for over 20 years. And so you can imagine 20 of those 21 years was doing it one way, and then all of a sudden, we're doing it a different way. And so, I think it's taken some time, to adjust. But personally, for Muskegon County, I can say that we have done our best to really work with these changes. It required some additional training on my part of my staff, and certainly of our law enforcement partners, but everybody was willing to really listen and start implementing these changes. And so I can say that although there may be some growing pains and some groans, we've been able to slowly make some of these changes a reality. For example, we had some issues with drunk driving, how that fits in the appearance ticket. And, Tom and I had conversations about that, and I think we've worked through those issues. But certainly, I think we're starting to see some being used to some of these changes. It's going to take a little more time, but we're getting there. As far as what the council can do, I think right now, it's a little early to tell what the benefits are. I'm hoping within the next 6 months to a year, we're going to be able to see some really strong data. I can tell you again, personally, from Muskegon County's aspect of it, we have been able to really manage our jail population as a result of this. For the first time probably ever, we've been below 300 as far as capacity, and our jail holds 520. So we're really seeing some positive results, and I appreciate certainly our sheriff as well as all our stakeholders. other than that, I know from the folks that are involved in this that we're able to certainly, as this moves on and we start seeing some potential changes, that I just hope that everybody's got an open mind and an ear to listen, and certainly what we want to do as prosecutors is certainly make the system better, more efficient, and as fair as possible, not only for those who are the accused, but more importantly, those who are affected by what's happening, the victims of crime. And so I know that for me personally, that open-mindedness has been there. And so I just hope that as we move forward, it's still there and we can still engage in conversations if in fact we find things that need to be changed, or if there's a solution that comes out of this. But other than that, again, outside of the kind of the growing pains as we make this big shift, I think it's gone relatively well. And we as an association communicate quite often with each other, and certainly if it comes to a point where we need some folks to come in and kind of guide us through, I guarantee you, after this year, we're going to be back to our kind of midwinter and summer conferences and the places that we like to go, and hopefully we can extend invitations to have those conversations. So hopefully that was brief enough, Chief. Again, I can't say enough of Ryan's efforts, and certainly of Mr. Boyd. I do appreciate that.
Thank you very much. No, that's perfect. Very, very helpful. And yes, of course, when you come across things in the future that need work, that's what we're here for. So that's exactly the point. So I really appreciate all the work you've done so far in that update. I was going to ask for one from Sheriff Clayton, but he is not here today. Why don't I go to Judge Fuka? Can you give me a court update?
Sure. I do want to concur with the prosecutor about what he said about Ryan and Tom. They're done a really nice job in laying all of this out, and it can look on its face a little confusing. And speaking on behalf of the judges, they didn't love it. I mean, as a group overall, judges don't want to be told how to do their jobs, and they think we think we know how to do it better than other people telling us how to do it. So, it was a lot of efforts went into calming their anxieties that's not as bad as it looks on its face. It's just a matter of making a good record. And I want to, before I talk about the district courts, Prentice and I did communicate with each other. He is on vacation, so that's why he wasn't able to be here today, but he did send me an email, so I'll read his email if that's okay.
Great. Yeah.
He said, given the wide breadth of legislative changes, Justice McCormick, along with Tom Boyd, have done a wonderful job in disseminating information to the bench in real time. MJI and SCAO have done several trainings on the changes, as well as provided web-based resources. Documents and materials seem to be readily available online or upon request. Continued training opportunities would likely prove to be helpful, but I think the learning curve related to judges getting accustomed to the changes is unavoidable. The biggest benefits I've seen so far have been in the areas of expungements and probationary sentences. We've been inundated in a good way with motions to set aside convictions based on the expansion of eligibility. I am also looking forward to seeing more probationers discharged upon early completion of their probation conditions. With all of the new policy changes, the necessary resources, primarily staffing, will have to be properly allocated for things to run efficiently. And then he makes a note that he would prefer more judges. So I can concur with a lot of the things that he said, and it kind of goes along with what I've said. Judges are slow. Some of us are slow to come around to some of these new concepts, and a lot of us like the ability to be punitive, and we think, at least in our minds, that that's going to get people to do what we want them to do. I don't know that that's always the case. And I think about my own small children, and I seem to have better luck when I incentivize them than when I ultimately punish them for their bad acts. I think that the criminal justice system works in a similar fashion. So personally, I'm super excited to see my probation department get to focus more on quality over quantity. I hear the common complaints from my POs that We just have too many, we have a volume of too many cases. We have a volume of too many cases. So I'm excited to give them just the people that they should be seeing. And then I'm hopeful that they will have more time to spend with those people. So, and maybe it's sending out an email that says, you know, you're doing a great job this month. You've made all your tests, or, you know, thank you for making that payment and we appreciate you making it. I think stuff like that goes a long way. And I do think that, you know, part of my training as a treatment court judge probably gives me that background as well, where we also see, again, that incentivizing good behavior seems to go a long way with our participants. I don't see any reason why that doesn't carry over to a traditional probationer. So we are starting to implement that stuff. I'm hopeful that we'll be implementing also a better screening process. So we do have a screening tool. I don't know that one tool is necessarily enough, depending on what the charge is. So maybe overlapping of some screening tools to determine, you know, what services, if any, are warranted for the defendants that we're seeing. So I'm hopeful that we see some of that. So with the legislation that's out there so far, I think it's a good start. And I want to say too that I checked today with our jail numbers, and our jail, Macomb County, can hold about 1,100 or 1,200 people, and that's kind of bursting at the seams. Prior to the pandemic, I mean, we were talking about doing a millage to rebuild the jail. I mean, I did a walkthrough of the jail. It's probably been 4 or 5 years, and I was it was horrifying. It was horrifying to me, especially to see where they were housing people with mental health issues. That part of the jail was archaic. It was like what you would see in a horror movie. And I thought to myself, if you're not have mental health issues before coming in, you're going to have mental health issues by the time you leave. And then I couldn't help too but feel a lot of sympathy for the staff, even the staff members of the sheriff's department who had to work in those conditions all the time, because it was really difficult just to go through that, even for the short period of time I was there. So it was really eye-opening for me, and for anyone who hasn't toured their own jail facility, it was really eye-opening for me. And it started a conversation between the judges and the sheriff's department on how we can be better stakeholders together and work together to try to alleviate some of these problems. But our jail was looking at being at max capacity. Before the pandemic, we were at about 900. Since the pandemic, we're now 400 or 500 inmates in the jail. So a lot of the initial release was because of the pandemic, but I think a lot of the continued lower rates of people being in jail are attributable to the bail reform and this new legislation. So now all the conversations about building a new jail, really, they're not looking at doing that anymore, right? At least right now, if the numbers stay where they're at. I think that's great for taxpayers. I'm hopeful that they're still looking at renovating the jail and figuring out better ways to handle the people with mental health, and also, of course, addiction issues and people that have to detox that are coming in, under the influence of substances. So all sorts of good things, I think, we have to look forward to. And I think that the legislation is already going in the right direction to help us get there.
Thank you, Judge, for all your work. Captain Hinz, do you have anything for us from MSP?
Obviously the state police is not in charge of the jails, but the troops have adjusted to this pretty well. It's just a little bit of a different mindset, and everyone has adjusted pretty well. And I think that really summarizes it. It's a change in mindset, but overall, I think that it's been a positive thing for us all, and we look forward to the future changes as well.
Thank you very much. Chief Riley, do you have any update for us? You may be stepped away. Takura, can I put you on the spot? Do you have any update for us from how the defense bar is handling it.
So I'm pleased about a lot of the changes, the way they're working out. And actually this coming Monday, I'll be arguing a motion that was brought by the probation department for somebody to be released from probation early from felony probation. Many of them, of course, not all of the changes I've touched, and we're looking forward to the ones that will take effect in October. I'm scheduled to speak to two groups, CDAM, Criminal Defense Attorneys of Michigan, at the upcoming conference. So a lot of my conversation will center around what we did with the task force and a little bit about this council. And I spoke with Lauren Kogali, the executive director of MIDC, last week, and I will look very quickly at the notes from our conversation, if you allow me 1 second to pull it up. So she is excited that this is the first year that there's true independence from the judiciary, not because any of the judges, current or former, on this call, ever did anything that caused belly aches for them. But there once was a time when people were concerned that, boy, if I don't do what it is that this judge expects, I may not get paid or I may not receive assignments. So this is a good thing. She feels that we're going in this direction. However, unfortunately, there are counties where even though somebody may have a case dismissed, where people are still getting charged fees. And, this is anecdotal, but starting next month, I'll be participating in the meetings with all the defender leaders. And I think these happen bi-monthly, so I will be able to report back with whatever it is that the people at the helms of all the public defenders offices would like me to share with the council. But, she's pleased. There are some growing pains, just like many of us are experiencing. But from my perspective as a defense attorney, I'm excited that we were actually able to breathe life into these recommendations, and that this second iteration of the task force was actually, we stood it up, because otherwise, they remain on paper, nice goals, but we never actually do what's necessary to make them functional. So I'm excited to be a member of this, and that many of the things are actually happening. So Monday, I'll be thinking about the work that we did in the task force and that we're doing now going forward.
Excellent, thank you. But I know that the rest of you also will have important contributions to make about how the implementation is going, and you will all have opportunities to present about that. For today, I thought this was the right place to start with the practitioners in the courtrooms and before the courtrooms. I don't think I have any other business. Let me ask Ryan and Tom if they have anything else they think we should do today.
I don't, Chief. Thank you, though.
Nothing from Tom. Any other questions or concerns from anybody else? I love ending a meeting early. It was great to see everybody, and I really look forward to working with you. And again, full of gratitude that you're willing to do this. Thank you very much.